Mr. Baloyi?
Well, I don't know what my learned friend is referring to.
I think we'll know when he raises it.
As the court pleases, but we have no objection.
Okay.
I must say, even though procedurally he would only have that opportunity if the court was to ask any clarity-seeking questions, and if he wants to ask questions arising from clarity-seeking questions by the court, that would be the only opportunity, my lord. There isn't really provision for him now to have another second bite at the cherry. But as I say, my lord, it's neither here nor there.
So are you opposed or?
Yeah. As I say, my lord, it's not procedural. But if he can indicate what those new issues are, my lord, so that we can properly...
Yes, Mr. Tovani, procedurally it is not
thank you, Your Lordship.
Time for that. Will you indicate the areas that you think?
If I may start in this way, Your Lordship, the Lordship yesterday indicated that we objected, and the Honorable Court indicated that if there is a new question, will be granted the opportunity, which procedurally is allowed if the state under re-examination comes with the new questions. My questions are even headed new questions to Tumelo. With regard to a name Buthelezi. Initially, when he testified, he never mentioned anything about Buthelezi. He never said anything about actions by Buthelezi. They only came up yesterday under re-examination. Hence, we objected.
But should your response be to get another chance to cross-examine, or for the court to expunge whatever he said about Buthelezi?
Yeah, it's not about a new chance of me cross-examining. It's a chance for me to cross-examine the new questions he answered from the state.
No, the thing is, you have already cross-examined. And the only thing that we can do is to expunge whatever he said about Buthelezi, which was out of 10. Because we are guided by the Criminal Procedure Act.
Yeah, but
I mean, by the criminal procedure rules.
Your Lordship, with due respect, we have a problem here because the state were allowed to continue under the impression the court made a ruling that will be allowed to ask based on only the new questions.
No.
Now, there's a change of heart today to say the procedure doesn't allow it.
There's no change of heart. What I'm saying is, if evidence came in which should not, the only response is to expunge such evidence, not to extend these proceedings unprocedurally.
That's where the problem lies, Your Lordship.
Yes.
The problem is the state came up with new statements and questions towards the witness, which they initially never asked the witness, which by itself, the state also never followed the procedure.
Then we should expunge that evidence.
With due respect, that's what I expected yesterday, but the court said we'll be given an opportunity.
Yeah, but that would not be procedural. If that evidence is expunged, what is wrong? What remains wrong?
As I'm saying, if the court says we'll expunge, and is that court that is the ruling of the court, I cannot dispute the ruling of the court. If the court makes a ruling that that evidence with regard to a name Buthelezi will be expunged, is the court that makes the ruling as a court basis.
Mr. Baloyi, there were instances, and I agree with him, there were instances where the witnesses, and I was even prompted to address the witness to say, answered only the question asked.
Yes. My lord, what Mr. Tovani is saying, it's not something new. That's actually what came up in cross-examination by Advocate Mshololo. the state questions were based on what Advocate Mshololo asked. The name came up during her cross-examination. We therefore submit it's not something new, my lord. And insofar as...
But do you agree with me that whenever it came up, whenever that name came up,
yes,
it was not within an accurate answer to the question posed?
Yes, there were some explanations.
The witness was time and again delving into an area which is not covered under the scope of the question asked.
Yes, that's in order, my lord. And as the court mentioned, once we receive the record, those extraneous issues will be expunged from the record. That's in order.
Mr. Madlala, we thank you for having come to testify. You had the issues around your interactions with establishments like Netflix and so forth. Now, there's a lot of people who might still testify in this case. Your duty is not to interact with those people in a manner that will influence their evidence. The best would be to wait until they have testified, if you must interact with them.
Uzwile Nkosi yami. Nkosi enkantolo yakubonga ukuthi uzwile wanika ufakazi. Bakhona ufakazi abaningi abasoza bazonikeza ufakazi kakhulukazi nalabo be-Netflix. Okukhulu kubalulekile ukuthi-ke wena-ke uzibambe ungahambi uyokhuluma nabo ngokunye kwale nkantolo okuzobona ukuthi kuya-influence. Sizona kahle ne? Understood, my lord.
As a court case, my lord, there was a request by our colleague yesterday for an early adjournment. We are not opposed to that, my lord. We can adjourn until Monday for the continuation of the proceedings. The date of Monday will be the
21st.
The 21st, my lord. 21st of November.
Although it is not central to, there was an issue that arose at the time Advocate Mshololo was cross-examining, and I was firm in the reasoning that it was not time for Mr. Tovani to make the inputs he sought to make at the time. Number one, because it was the time for Advocate Mshololo to address. Number two, I wasn't even sure whether whatever he was saying belonged in these proceedings. So I was saying whatever it is, it should be done outside these proceedings. And whatever implications it has, we shall see when it happens. But I wouldn't allow an instance where one practitioner is cross-examining and somebody else comes with a motion, if it's a motion, towards whatever direction. So these things I believe should be sorted out amongst the three of you.
As a court business, hence precisely our humble request for early adjournment. If the state is not opposing and Advocate Bamsholo is not opposing, there's no need for me to give reasons. Hence, I did indicate to the court that I will require to consult with clients for direction. Then,
yeah. Well, all I'm saying is that we should not debate it here. It doesn't belong here.
I agree with the court.
But then we need, the four of us need to converge to meet immediately after we adjourn. The reason why we should meet it's something that I could simply do with Advocate Baloyi, but it would not be correct to meet Advocate Baloyi aside.
I agree with that.
So we should go and meet in chambers so that we can quickly discuss that. Ashley?
Your Lordship, my colleague will accompany me as well.
Yeah, well.
Thank you, Lordship.
So we should go directly to the chambers. Please rise. This case is postponed with the accused in custody. It's postponed with the accused in custody until Monday, the 21st of November for further hearing. I think the only other thing to say is that the four of us have to converge in chambers.
Right, sinasukuma sonke manje.